For years, the public has been given a clean, contained version of events. Donald Trump knew Jeffrey Epstein, that much was acknowledged, but Melania Trump was portrayed as separate from that world, an outsider, a model who happened to meet a powerful man at the right place and time. The story was repeated so often it hardened into fact. It appeared in profiles, documentaries, and campaign-era mythology. It was meant to end the conversation, but according to newly filed court documents, that version of events is now being formally challenged. Not on social media, not through anonymous leaks, in filings submitted under oath. These papers do not argue tone or perception. They focus on access, proximity, and what the record allegedly shows when public relations narratives are stripped away. This is not about speeches, photo ops, or carefully edited films. It is about what has been placed into the legal system, where claims carry consequences. Once allegations are made in court, they are no longer just stories. They become assertions that can trigger discovery, testimony, and sworn answers. And that is why this moment matters. The timing is not accidental. These filings surfaced during a period of heightened national tension, when public anger toward political elites is already near a breaking point. According to reporting and procedural timelines, they landed just as a major image rehabilitation effort was underway, designed to present Melania Trump as a symbol of dignity and distance from controversy. That contrast is critical. On one track, a carefully managed narrative of grace and patriotism. On the other, legal documents alleging a far more complicated past. The optics alone are combustible. According to the record, the filings coincided with public events that many perceived as tone-deaf, reinforcing the sense that powerful figures live under different rules. Public frustration was already primed. The allegations did not create that anger. They poured accelerant on it. And behind the scenes, legal pressure was quietly building. That pressure began with what appeared at first to be a familiar move. According to court records, Melania Trump's legal team issued a threat of litigation against a journalist who had made claims about her past associations. The demand was sweeping, warning of massive damages and reputational harm. In most cases, such letters achieve their goal. They chill reporting, they force retractions. This time, according to the docket, the response was the opposite. Instead of backing down, the journalist filed suit first, a declaratory judgment action invoking New York's anti-SLAPP laws, effectively daring the claims to be tested in court. That move changed everything. What began as a reputational dispute became a procedural trap, because once a case is before a judge, the question is no longer who looks bad. It is what can be proven. This is where discovery enters the picture. Subpoenas, depositions, sworn testimony. The process that powerful people fear more than headlines. According to the filings, the lawsuit is no longer about defending a public image. It is about controlling what evidence might be compelled. And that is where the documents become explosive. At the center of the case are allegations tying Melania Trump more closely to Jeffrey Epstein's social world than previously acknowledged. The filings allege not a casual overlap, but sustained proximity, relationships, invitations, access. According to sworn declarations, she was not merely adjacent to that circle, but present within it during a period now understood to be rife with criminal conduct. The language in the filings is careful, but the implications are severe. They allege that introductions were not coincidental, that social interactions were facilitated, that the environment was known even then for behavior that would later be exposed as predatory. These are not claims of guilt. They are claims of presence. And in cases like this, presence matters. Then comes the allegation that has caused the most visible panic. According to the filings, a recorded statement exists, attributed to Epstein, in which he allegedly claims responsibility for introducing Donald Trump and Melania and places their first intimate encounter aboard his private aircraft. That aircraft is infamous for a reason. Its name is synonymous with a criminal enterprise. The allegation does not merely shift a detail, it recontextualizes an entire origin story. If true, it would mean that the beginning of one of the most consequential marriages in American political history occurred within a space later identified as central to sex trafficking crimes. That does not establish culpability. but it raises questions that cannot be answered with press releases. It reframes Melania Trump not simply as a passive figure, but as someone whose proximity to power and abuse may have been far closer than acknowledged. The response from Melania Trump's legal team has been swift and categorical. The allegations are described as false, defamatory, and unsupported. They point to the absence of her name on certain flight logs and argue that speculation is being dressed up as fact. On its face, that defense sounds decisive, but under legal scrutiny, absence is not always exculpatory. According to the counter-arguments in the filings, flight logs were not comprehensive records of all passengers. They were operational documents. The claim is that not everyone present was recorded, particularly those not meant to be visible. This is not a proven fact. It is an argument, but it is one that, if accepted by a court, opens the door to deeper inquiry. The filings also raise questions about immigration history, specifically how Melania Trump obtained an EB-1 visa, a category reserved for individuals of extraordinary ability. According to the record, critics have long questioned how a relatively unknown model qualified for such status. The filings suggest examining who at the time had both the influence and the pattern of assisting models with immigration matters. Again, this is framed as an allegation, not a conclusion. But it is precisely the kind of question discovery is designed to explore. This is why the stakes are so high. If the case proceeds, it is not just about public statements. It is about emails, financial records, calendars, witnesses, and sworn testimony. According to the filings, the plaintiff seeks to ask direct questions under oath. Did she ever observe minors at Epstein's properties? Did she ever receive money or assistance from him? Did he play a role in her immigration process? These questions have not been answered, and that is the point. From a legal perspective, this explains the ferocity of the response. In defamation law, truth is an absolute defense. Even substantial truth can be enough. And to test truth, courts allow discovery. According to the record, the real danger is not a jury verdict. It is the process itself, the exposure, the paper trail, the possibility that carefully maintained silence might be broken under oath. Zooming out, this case lands in a broader moral and political moment. Public faith in institutions is collapsing. Elite immunity is being questioned. The contrast between polished propaganda and raw legal documents has never been starker. On one screen, a curated image. On another, allegations preserved in court filings. One is designed to distract, the other to compel answers. This is not just about one woman or one marriage. It is about how power operates, how narratives are constructed, and what happens when those narratives collide with the legal system. Courts do not care about symbolism. They care about evidence. They do not evaluate charm. They evaluate credibility, which brings us to the only question that ultimately matters. Not whether these allegations are comfortable, not whether they are convenient, but whether, when placed under oath, they can be denied without contradiction. Because if the filings are wrong, discovery will expose that. And if they are right, the consequences extend far beyond reputational damage. So the question is not whether you like this story. The question is whether you believe the truth lives in documentaries and speeches or in sworn filings and depositions. Because if this case moves forward, someone will eventually have to answer a simple question, under oath, with no script and no edits. What did you see? That is what this legal battle is really about. If you believe court records matter more than curated narratives, engage with this story, examine the filings for yourself, and stay alert. In moments like this, attention is not entertainment. It is civic responsibility.